Judgment in the appeal, the Queen on the application of Ali and Bibi and the Secretary of State for the Home Department.
Our immigration system has for many years sought to control so-called primary breadwinner entry, while then accepting that spouses and partners and other family members sometimes should be allowed to join the breadwinner here. In 2007, for the first time, the UK required people who had come here to join their spouses and partners to show sufficient knowledge of the English language and life in the UK before they could be granted indefinite leave to remain here. The government then floated the idea of introducing a pre-entry language requirement, with a view to ensuring that everyone who came here to join a British citizen or person settled here as a spouse or partner had a basic level of English language skills before they arrived. Originally, it was decided that this could not be implemented because of a lack of available courses overseas, which would simply keep, in the government's view, British citizens apart from their loved ones, breaking up families. Instead, foreign spouses would be required to enter into an agreement to learn English. But in 2010, the decision was taken to implement a pre-entry language requirement, that foreign spouses and partners demonstrate a basic level of English language skills before they came to this country. Certain countries where the majority language was English were exempt. These two cases concern women who are British citizens married to foreigners. Mrs. Bibi was born in Coventry and lives with her family in the West Midlands. In 2009, she married her husband, who is a citizen of Pakistan. They have a child who lives here with his mother. Her husband neither speaks nor writes English. To obtain English tuition at the level required, he would have to relocate for several months, which he cannot afford to do. Mrs. Ali is married to a citizen of Yemen, who does not speak any English and is illiterate. Even if he could gain access to appropriate tuition, there is no centre in the Yemen where his language skills could be tested. These proceedings were launched before the new requirement came into force, with a view to challenging the validity of the rule itself, as an unjustified interference with the British settled spouses' rights to respect for their family lives. The problem with this argument is that there are some, perhaps many, foreign spouses and partners who can easily meet the requirement. If they can, the rule does not infringe the Convention rights. Therefore, the court cannot strike down the rule itself. But it is obvious that there are some spouses or partners who cannot reasonably be expected to comply with it. The rule reflects the legitimate aim of ensuring that new immigrants to this country have sufficient language skills to be able to integrate into society here. But there will be some people for whom it is impracticable, without incurring unreasonable expense, to gain access to the necessary tuition or to take the test. So the practical application of the rule will be incompatible with the Convention rights of their spouses or partners here. The current guidance on the rules is not sufficiently sensitive to pick up these cases, or all of them. Hence, although the rule itself cannot be declared incompatible, there may be scope for a declaration that its operation in certain circumstances will be incompatible. This is not the remedy that the claimant sought, so the court will invite further submissions on what, if any, declaration we should make. The court is now adjourned.